Hello and welcome to this webinar on foreign language clients. My name is Ollie Foy. I'm a barrister at Pump Court Chambers. This webinar is another instalment in Pump Court's new practitioner series. I hope to give some introductory pointers and guidance relating to the situation when the client's own language is not English. This shouldn't be a cause for panic, but in such a situation, certain steps do need to be taken to avoid derailing a trial and, of course, to avoid a nasty costs order as a consequence. This presentation will be limited to two particular issues for foreign language clients. What are the rules for witness statements? And logically, following on from that, how can the client give evidence? And that will require the use, usually, of an interpreter. When is action needed? Well, the moral of the story, when you have a client who does not speak English or cannot read English or cannot do either of those things very well, is to take action early. The problems arise when you get all the way to trial or close to trial, and it transpires that the rules for witness statements have not been complied with and an interpreter hasn't been booked for the hearing. Invariably, the reason for that is because it hasn't yet become apparent that the client has difficulties with English. It is not uncommon for this to only become apparent when the client begins giving evidence, and even after a full conference with counsel, it transpires that they do not understand their witness statement, and that leaves the court and, of course, the client in a very difficult position. So the initial contact with the client and the proofing stage is very important. Instructions can, of course, be taken in numerous ways. Statements can be prepared in numerous ways. If, for example, everything is done via an exchange of emails, it might not be obvious that the client is being assisted by a family member who can read and write in English, and that family member hasn't appreciated the future issues that may arise when the client comes to give live evidence. It is worth checking proficiency in English. It is worth checking that the client understands the witness statement, which should be in their own words anyway. A telephone call should give you some indication, and the test will be whether the client will be able to cope and deal with cross-examination, whereby the client will be taken to their witness statement, to the pleadings, to the medical report, etc. So certainly by the end of the proofing stage, it should be clear whether the client has a sufficient command of English to give their evidence in English. Witness statements. Where you need to go to is Practice Direction 32 of the CPR. That contains the relevant provisions for witness statements. And we can see here Practice Direction 32, paragraph 18.1. The witness statement must, if practicable, be in the intended witness's own words and must, in any event, be drafted in their own language. Practice Direction 32, paragraph 19.18. A witness statement should be drafted in the witness's own language. These provisions beg the question, don't they? What is the witness's own language? Well, Practice Direction 57AC, paragraph 3.3, which relates to witness statements in the business and property courts, provides some helpful guidance. It says that a witness's own language includes any language in which the witness is sufficiently fluent to give oral evidence, including under cross-examination, if required, and is not limited to a witness's first or native language. The litmus test is therefore whether the client is able to give evidence in that language. Just because English is not someone's first or native language does not mean English is not their own language. So long as they can give evidence in English, the witness statement can be in English. Practice direction 32, paragraph 20.1, which I put on the slide there. A witness statement is the equivalent of the oral evidence which that witness would, if called, give in evidence. It must include a statement by the intended witness in their own language that they believe the facts in it are true. If a client has signed a statement of truth without understanding the words, and without understanding the words in the witness statement, that is arguably a defective statement of truth, which brings part 22 into play, and it's likely to be argued that the witness statement has not been verified and should not be admissible. I've referred in the slide to part 32.14, part 32, paragraph 14, and in the slide, I've referred to that because it enshrides the principle that proceedings for contempt of court can be brought against anyone who makes or causes to be made a false statement verified by a statement of truth without an honest belief in its truth. That will not always come into play where a statement is wrongly drafted in English, but it certainly raises the prospect and should reinforce attempts to ensure the client understands what they are signing. It's important to note the mechanism in practice direction 32, paragraph 23.2, which is also on the slide. It says this: where a witness statement is in a foreign language, the party wishing to rely on it must have it translated and file the foreign language witness statement with the court, and the translator must sign the original statement and must certify that the translation is accurate. What then needs to happen is this: the witness statement has to be written in the witness's own language. And then it's that witness statement which is translated into English. Quite often, I've come across witness statements written in English, which are then translated into the witness's own language. That is the wrong way around. It doesn't comply with the practice direction, and it invites questions about how the English witness statement was taken and understood. The need to understand witness statements is similarly true of pleadings and other documents, such as medical reports. If it becomes clear at trial that the client can't really understand or read English, then the other side may well ask how the client understood and gave instructions for the particulars of claim. If the client attended the medical appointment without an interpreter, there will be an obvious doubt about whether the consequent medical report is accurate. So the validity of the whole claim can tumble like a house of cards if these rules aren't complied with. And it is important, obviously, to ensure that the client is understood and given appropriate instructions throughout the claim, and not just for the witness statement. Non-compliance. What then happens if the rules haven't been complied with come the trial? The first thing to say is that the evidence will be treated with caution. Ultimately, the issue is that client has signed something which they did not understand. A lamb and a lamb is a case where everything that could go wrong seemed to go wrong. And what happened was as follows. A witness statement was filed in Urdu with an English translation. During cross-examination, it became clear that the witness did not speak, read, or understand Urdu. This meant he could not read his Urdu statement or indeed the English translation of that statement. His witness statement at the time it was made was given in Punjabi through another witness as a translator to a solicitor who did not speak Punjabi. The witness statement was initially prepared by the solicitor in English, translated to Urdu, and then back to English for the certificate. The witness was asked whether he just accepted what was put in front of him as his evidence, and he agreed with that suggestion. Therefore, the judge was left with the inevitable conclusion that the evidence simply had to be excluded. And so that is a situation which you really want to avoid. One potential method of dealing with the issue, if there is an interpreter in attendance, is to ask the interpreter to translate the witness statement for the client and to confirm that it is correct in the client's own language. And that is a potential course of action. It's certainly not going to be accepted in every case in the face of various breaches of the CPR, but it could be proposed in accordance with the overriding objective to deal with things on the day. But the more likely scenario, when you're faced with these various breaches and the witness statement is non-compliant, is that the court will be faced with either adjourning the trial so that the rules can be complied with, or with striking out the claim. Both of these options are likely to have consequences, which is why it is so important to identify issues with language at an early stage. If a client needs an interpreter, it makes complete sense to instruct one early on. The services will not be free, so the client's instructions will need to be taken. The terms and fees of the interpreter will need to be approved. One of the drawbacks, admittedly, of instructing early is that the case might settle or the trial might be adjourned. Therefore, it's important to clarify whether any fees will be payable by the client and whether the client is happy to press ahead with the instruction in those circumstances. The pre-trial checklist includes a section in which you can tell the court whether an interpreter is needed. However, there's no need to wait until then. It would be useful and efficient to inform the court that an interpreter will or is likely to be attending as soon as you know that to be the case. That can then be accommodated practically. For example, if a remote link needs to be sent out to the interpreter and can be accommodated into the time estimate if necessary. I've referred to the equal treatment bench book in this slide because it contains some interesting comments on the use of interpreters. It's highlighted that appearing in court and giving evidence is quite different from being able to communicate when shopping or working, for example. And I'm just going to read one particular paragraph in relation to interpreters from the bench book. Situations may arise where the judge has to take a proactive role and make some effort to clarify and resolve the extent of any language difficulty faced by a witness. It is part of the judge's function to check everyone understands each other so as to ensure a fair hearing. If a judge hearing a case considers that an interpreter is required, an adjournment should be granted for that purpose. So the key here is that judges must ensure that the hearing is fair And having an interpreter is fundamental to that, or can be fundamental to that. But it should nevertheless be borne in mind that an interpreter is not a divine right. In Shuka, the case I've cited there, a litigant in person's application for an interpreter was dismissed. The litigant in that case had a sufficient command of both written and spoken English, and an instruction of an interpreter was disproportionate. Interestingly, the combination of Article 6, which applies to hearings determining civil rights and obligations, and the overriding objective were not sufficient for an automatic right to an interpreter. And importantly, in this case, it was about the applicant addressing the court through an interpreter rather than giving evidence through an interpreter. And the proper course of action in those circumstances was said to be to instruct an English lawyer. Well, there you have it, a crash course in witness statements and interpreters for foreign language clients. I hope that was useful. I hope there's some useful guidance in that talk. Thank you very much for listening.